If this case was about really the enforcement of U.S. securities laws, it would have never been filed. It would have been settled. Ripple has agreed that they would settle the case before they said they were willing to settle, and they've publicly, their general counsel and their CEO have publicly stated that they would settle today.
In today's video, Attorney John Deaton discussed the latest with the SEC Ripple XRP lawsuit, the recent summary judgments from Ripple and the SEC, and what's next for the procedural process, likelihood of a settlement soon.
All eyes are on the Southern District of New York, still waiting anxiously for a decision in what I and others have described the most significant non-fraud SEC enforcement action in history. 2 years ago, it was just XRP holders who were waiting anxiously. Now it's the entire crypto world. And as we wait for her decision, we're going to ask the question that some have asked on Twitter, which is, what is an unbiased application of U.S. securities laws, existing laws, as it applies to the Ripple case? Now, I've been on record to tell everyone that if this case was about really the enforcement of U.S. securities laws, it would have never been filed. It would have been settled. Ripple has agreed that they would settle the case before they said they were willing to settle, and they've publicly, their general counsel and their CEO have publicly stated that they would settle today if, in fact, the SEC would agree to ongoing future sales, secondary market sales. But that's not what's at case. Now, the question before us is, what is an unbiased application of existing U.S. securities laws? Now, notice I didn't say fair, because we're going to talk about a few things like that. But fairness is an issue because the fourth affirmative defense of Ripple is called the fair notice defense. And before we get into explaining that, we need to understand what the fair notice defense really is and what it isn't. To fully comprehend it, we must distinguish it from what's been tried before. For example, in the library case, in the Kit case, in the Telegram case, there was a lack of notice argument and they all failed. And we also need to distinguish Ripple's fair notice defense from the concept of selective enforcement, right? There's a lot of people out there, XRP holders, that say, but ETH's ICO, they didn't sue ETH, and that was clearly an ICO. And then they put up there on the graphic, look at what happened in the market. That's not fair. Listen, selective enforcement is maybe the weakest defense I could ever think of, because you're basically saying, well, they broke the law too, so why don't I get a pass just like they get a pass? So you gotta set that aside. It happens. It happens all the time. Why one company gets sued and others don't? Why was Ripple picked? Look at all the other tokens out there. So that's the other concept that we need. Now, I personally believe that securities lawyers have dismissed too quickly the fair notice defense that Ripple is offering in the case. And I believe it's because they're confusing it with what's been tried before. What's been tried before by the other cases wasn't Ripple's fair notice defense. It was that the term investment contract is too vague when you apply it to blockchain technology. What's previously failed is that they say the Howey test. The Howey test doesn't provide an adequate notice to a crypto blockchain entrepreneur to know what is prohibited and what's not prohibited. Those were tried. That argument was tried several times in previous cases, and they all failed, and they should have failed. And some of you might be surprised by that. But the law is the law. And yes, Congress should modernize the law, but it is what it is. And so, but when we go to the Howey test, actually the Supreme Court in 1946 actually anticipated this. They gave a ruling knowing that there would be other applications of it, and they called it a flexible test. In fact, in the Supreme Court, and how he said the test embodies a flexible rather than a static principle, one that is capable of adaptation to meet the countless and variable schemes devised by those who seek the use of money of others on the promise of profits, end quote. And so what did we learn from that? It's been applied to beavers, to chinchillas, to condos, and yes, to even Bitcoin in 2013, where it was used as an investment contract. And so how he is flexible. So therefore, arguing the general vagueness of the statute or how that's asking the court to do Congress's job, and it's not going to happen. So it should fail, but that's not what Ripple is offering. It's not even close to the Ripple fair notice defense. Ripple's fair notice defense is very specific to XRP and very specific to the way agencies in the government, including the SEC, especially the SEC, treated XRP. Okay. So what we're going to do, and I believe Ripple's fair notice defense has some real teeth to it. But understand that we don't get to the fair notice defense unless Ripple loses. So if Ripple were to get an outright win, the judge would never even talk about the fair notice defense. It would be moot. However, if the judge finds that Ripple at some point in time from the beginning until today sold XRP or offered it as an investment contract, aka security, then the fair notice defense kicks in, and it may go to a jury unless the judge agrees with the SEC that no reasonable jury could conclude that Ripple didn't get fair notice. And we'll talk about that. But so now that you understand where it's relevant as far as the fair notice defense, I believe the SEC will lose its outright summary judgment. And if the judge finds that Ripple at some point XRP was offered and sold as a security, then it would go to the jury for the fair notice defense. So if the SEC wins, it's going to go to a jury, in my opinion. First possible outcome is an outright Ripple win, where the judge accepts the blue sky argument and says there's no investment contract, there's no contract involved, there's no post-duty sale obligations, any of that. I'm going to agree. You don't got to take it up on appeal, and Ripple wins. I went on record. I don't think she's going to do that. I think it's a great Second Circuit argument. I think the Supreme Court will accept it and adopt it, but I don't think she necessarily will. I think it's too aggressive for her. I hope I'm wrong. But so Ripple could win outright on a different basis, and that's where the judge says, SEC, you went with this all or nothing theory that all XRP, it was, is, and forever will be, no matter who sells it, under no matter what circumstance, security. You went with that all or nothing theory, and so you get nothing. Ripple wins. Okay, that's one outcome. Second outcome, judge says, I find that Ripple in the early years violated, the securities laws and offered and sold XRP in the early years for specific time. She could even go, as far as saying all the way up to present day, excluding ODL, because ODL's not. That's a possible scenario, but that today's XRP secondary market sales are not securities. The third outcome is that the SEC wins outright. I got that at 0. Now maybe I shouldn't have it that low, but that's how confident I am about that, meaning that ridiculous theory of theirs. And then the fourth outcome is the judge says jury issue for common enterprise, or whether or not there's non-investment purposes of XRP, or whether or not XRP holders reasonably relied on the efforts of Ripple, and nobody wins. It's a draw at summary judgment, and it goes to a jury trial. Those are the 4 options. Now, what would I do? Well, it's not going to surprise some of you. I've been a federal prosecutor. I believe that the prosecution must own its theory. And I believe that the SEC may have snatched defeat from the jaws of victory. Some of you will disagree, but I believe I could beat Ripple if I was very specific about certain transactions. I think I could make the case. The SEC didn't go that route. They went with all cells, no matter what circumstances surrounding the cell. So because that's what they put all their eggs in that basket, I would find for Ripple. Now, why do I say they snatched defeat from the jaws of victory? Because every altcoin starts off as a security, arguably, okay? If Satoshi Nakamoto, when he was the only one, or she was only one mining, or they was only one mining Bitcoin, it decided to say, I'll sell you 100,000 Bitcoin to someone for 50 grand and, just sit back and hold it. This is going to take off. That would meet the Howey test. Okay. So when Ripple created XRP, the founders did, and then gifted 80% and kept 20%. At that moment in time, they were the only ones that had XRP. So yes, they could sell it to an accredited investor, but they needed to create a secondary market. They needed to create certain things. So those initial transactions could be, doesn't have to be an ICO. An ICO just makes it cleaner to call it an unregistered security. So, but the SEC didn't prosecute the case that way. The only thing when you go through it that it did was say that there were a couple instances where Ripple, for example, in 2014 sent 100 brochures to about 100 people about XRP. Judge Torres could find that particular transaction of sending that brochure to about 100 people about XRP constituted an unregistered securities offering, because at that point in time, there's just not enough in the ecosystem. So that's what I mean by snatching defeat from the jaws of victory. Like I said, imagine when those first sales are made, even with a venture capitalist, if you say, here is 1 billion XRP at an option contract, but you don't put limitations on how they can sell it. If the scheme is to create a secondary market to build liquidity and momentum, that at some point in time in those early years meets the Howey test. And that's what I meant by an unbiased application of existing U.S. securities laws until Congress changes it and does something like the FCA in UK or like the FSA in Japan or other entities, foreign jurisdictions out there, unless they designate it a certain way and do what they should, like call an XRP a utility or exchange token or hybrid thereof, then we have to deal with this 1946 case. So wanted to explain to you, I'm confident that the judge will say that secondary market sales are not in play, that secondary market sales of XRP are not securities, that the token itself is not a security. And I say that just because of XRP holders amicus brief, Coinbase amicus brief, Blockchain Association, Digital Chamber of Commerce, and the slew of others, Spin the Bits, and everyone else, that TapJets, iRemit, all of that. There's so much attention on this case. I think she will feel morally obligated to have to address those issues, even though she technically doesn't, if she wanted to try to avoid them. I don't think she will. I think we have a great judge, and we will see.